Okay, my name is Noelle Hicks. I am a shareholder here at Roberts Markel Weinberg Butler Haley in our Houston office. I want to thank everybody for joining me on this rainy Tuesday. Hopefully, you guys didn't have to get your boats out to get to work today, or maybe you're able to join me from home, which is always the better option, right? Anyway, today we're going to spend a little time talking about board meetings. We're going to do a little one-on-one course so that we can, wrap our minds around board meetings, what's required, so on and so forth. So we're going to give our disclaimer. The information presented today is based on the law as it exists as of today, May 9th, 2023. We are presenting this information for educational purposes, and it's not legal advice. But if you do need legal advice for any of the things that I mentioned to you today during our presentation, then make sure you consult with your attorney. So our goals for today are going to be to discuss governing documents. I'll go over that briefly. We'll talk about the role of the board, the reason for board meetings, planning for the board meeting. We'll talk a little bit about board meetings themselves, and then we'll get into our conclusion, and I'll send you guys off on your way on this Tuesday. So let's get started with governing documents. Of course, we all know what governing documents are, but just as a brief overview, the association is governed by what we call our governing documents or our dedicatory instruments. And the one that we're all most familiar with is likely the restrictions or the covenants, conditions, and restrictions. But there is a document that takes a little bit of precedence over the deed restrictions or the declaration, which is the plat. And of course, the plat is a map that gets filed in the real property records, and it's going to show all of the boundary lines, lot lines, and everything for lots, for streets, for common areas, reserves, all the easements and things of that nature that go in the community. And it just kind of helps to establish what the community looks like. You'll also notice sometimes on plats that there are certain restrictions contained in the plat as well. Those would certainly override any restrictions that are located anywhere else. But the main document that we look at for things like use restrictions, a collection of assessments, and other things are, of course, those deed restrictions. Some other governing documents are the article of incorporation or the certificate of formation. That's how the association itself gets formed. And it most likely is formed as a nonprofit corporation here in Texas. Then also we have the bylaws. And of course, the bylaws are the things that help the board govern themselves. Talks about how the board should hold their member meetings, their own board meetings, how elections should be conducted, and other information like that. So the governance really of the board is contained in the bylaws. Sometimes there are other governing documents or dedicatory instruments like builder or architectural guidelines that kind of help the association with how new construction, for example, or improvements should be done. And then sometimes we have other rules and regulations, and kind of the first thing that pops into my mind is like pool rules, or if we're talking about condominiums, the regulations about how common areas should be used or maintained, or who has a responsibility, like a responsibility matrix, who has the responsibility to maintain certain common elements versus, inside of the unit. So we'll move on a little bit, but of course, the governing documents provide that structure for the board to work within, and we find the board's authority to govern the operation and regulation of the association, mostly in the bylaws, but again, some of that information could be contained in the deed restrictions as well. But in general, those dedicatory instruments provide the rights and responsibilities for the association members, which protect the interests of the community. So in general, we want to make sure that we are protecting those property values. We're making sure that the properties are being maintained properly. We're maintaining or keeping that aesthetic in the community that's actually set out in the governing documents. So now what's the role of the board? Well, generally, the role of the board can be found in the Texas Business Organizations Code. A lot of times the roles of the board are restated in the bylaws, but a lot of times there are questions about what exactly the board can do, or what the association or the board as its representative can do on behalf of the members or the owners in the community. Well, the board, before it even gets to the stage of operating the association, the board needs to be able to put its personal preferences aside. Now, of course, we know this is a volunteer role. Board members volunteer to help kind of govern the association, but they need to be able to do that without those certain biases that we can all have, or maybe, without any discriminatory practices. And so one of the things that the board really has to be able to do is to put their personal preferences aside. One of their main goals is to make sure that they are preserving and improving the quality of life for residences. And in order to do that, really, you have to put your personal preferences aside and really put the well-being and the best interest of the community ahead of your own. The board should also know the roles or the differences in the roles between the board and the board members themselves versus the community manager, right? The community manager is there to assist the board in the governing and operation of the association. So those roles are not the same, and understanding the differences between those roles is really vital. Board members also serve as representatives of the community. So of course, from time to time, you will have members, coming to board members to talk about certain issues that they see going on in the community. But in general, the board will do things like entering into contracts on behalf of the association, or they will, make sure that the association has the proper safety channels set up. So it's really, they're representatives of the community as well. The board's also going to make decisions on governance of the community. So it would adopt certain policies when it sees things come up that maybe a policy or certain rules and regulations are necessary. Or if it finds things in bylaws that might need to be changed, the board has the authority to change those bylaws without any membership input. And so, for example, when we're talking about bylaw changes, one of the major things that I see is quorum requirements. A lot of times associations have a hard time meeting their quorum requirements. And so they might see that it's beneficial to actually amend the bylaws to change those quorum requirements to lessen them, or even to put what we call a stepped down quorum requirement, so that if we hold a meeting and the quorum doesn't get met, then you can adjourn that meeting and recall the meeting within like 5 minutes to still be able to try to conduct the business that would have gone on in that meeting and have that quorum present. The board can also do things like establish the budget, increase or decrease budget where it sees necessary, and things of that nature. But keep in mind, the primary role of the board is to protect and increase property value of residents. And that really comes into play when we're talking about deed restriction enforcement and things of that nature. So the board needs to be very familiar with the governing documents and what their role as board members really is. Now, why do we have board meetings? What's the reason for board meetings? And this can vary the amount of times that you have board meetings, but what's the point? Well, the property code, and I'll talk about this a little bit later, sets out certain things that are required to be done in an open board meeting. But it's for transparency purposes. But in general, the board has to do certain things in front of the entire community. So, and discuss those things, maybe consider and vote on those things in open board meetings. So a couple of the things are establish a budget. They can review the financials of the association. They can even discuss the collection and enforcement efforts. Of course, that kind of thing needs to be done more privately, because you don't want to, talk about individual homeowners' business in front of everyone, right? You don't want to put their business out in the street. But, certain things that are contained in this list right here are the reason why board meetings are important and why they are required to happen, and they're required to be open to the entire community. Of course, they would discuss contracts. So if there are some sort of vendor contracts that need to be talked about, landscaping, for example, and if you're taking bids on a landscaper, then that sort of thing needs to be discussed in open board meetings. Actions between meetings need to be ratified or discussed during an open board meeting. But again, those are for transparency purposes. And then a lot of times it's gives owners an opportunity to come and express their concerns as well, which I'll talk about in just a few minutes. Now, let's get into planning for the board meeting, because that's really important. You got to make sure that you're finding places that are large enough, that are private enough, and that they're air conditioned. Those sorts of things are all things that really need to be brought into consideration when we're talking about figuring out a location for a board meeting. So maybe the community has a community center or some other facility that's large enough to accommodate all of the members in the community, or all of the people that you anticipate showing up to the board meeting. Can that meeting be held in the management office? Is the community a little bit smaller, and likely that you're only going to have maybe 10 to 15 people. Sometimes associations consider having their board meetings in restaurants, or, maybe there's a community that I'm familiar with that uses a meeting room in the local police station. I have seen associations have their meetings at grocery stores. So, for example, in Conroe, there's a grocery store that has a meeting room on the second level of the grocery store, so that that room can be used to have board meeting as well. Is it beneficial, or is it convenient to have it at someone's residence? These are things to consider. I've seen communities have their board meetings in one of the residences in the community as well. Or should it be held outdoors? Now, I don't know about you, but in Houston, I want to do nothing outdoors because it's always 12,000 degrees outside. But if you have a nice location, maybe by the pool, something that's shaded, something like that, maybe it would be a good idea to go ahead and have it outdoors as well. But it really just, you have to take into consideration the size of the community, how many people you anticipate showing up, the time of year. If it's near Christmas time, maybe a lot of people won't show up because people are on vacation or something like that. But those are just things to consider when you're planning for your board meeting. Now, also another thing to think about is who's going to be in control of the meeting. And this is something that probably should be discussed before the meeting actually takes place. Whether or not one of the directors of the board is going to be in control of the meeting, or if the community manager is going to control the meeting. Now, I have seen it done both ways, but it really just depends on the community and what you think is best for the community that you serve. You really need to make sure that you set the tone for the meeting, whoever it is that's going to be actually controlling the meeting. Set the tone. That's important, especially if, for example, you anticipate having a contentious meeting. And in the case where you might have a contentious meeting, maybe a consideration for security is something that needs to be discussed. But regardless, everyone who is sitting at that front table, or everyone who's a board member and or a community manager, needs to assist in control of the meeting, even if you're not the person that's directly in control of the meeting. We all know that sometimes board meetings can go off the rails. We all do our best to kind of stick to those agendas that we prepare, but we can't control everything. So we all need to just kind of work together to make sure that we're keeping the meeting on track and keeping control over the meeting as best as we possibly can. Now, one of the ways that we can keep a meeting under control is to make sure that we have a well thought out agenda. Now, of course, before this meeting gets started, you have sent out this agenda along with your meeting notice, right? You distribute that agenda at the meeting itself, or you can maybe project it on a wall if you have a PowerPoint presentation or something like that you're going to do. Obviously, your agenda needs to be informative. It needs to state exactly what's going to take place at the meeting. And it should say something like the board will consider or vote on a landscaping contract, or approving the budget, or something like that. But the key to this, though, is to make sure that you stay on track. Go through your agenda exactly as it's stated, and so that way it will help. Now, it's not going to always prevent things from kind of going off the rails, but it'll definitely help you stay on track, help you stay within the time limit that you prescribe for the meeting, which is always important because sometimes those meetings can go on for hours and hours, it seems. But if you have a meeting that you have set for 1 hour, make sure you stick very tightly to that agenda so that you can get through that meeting in 1 hour. And I'll talk a little bit about how to prevent things from kind of going over time in just a few moments here. Another thing, and actually this is one of the things that could send the meeting off the rails or send it over time, is the owner forum. So you need to consider whether or not you will be having an owner forum at your meetings, at your open board meetings. And a couple of things that need to be considered with the owner forum is whether or not you are going to limit a homeowner's time to talk, which I absolutely recommend. I recommend that an owner be given 2 to 3 minutes to either ask their questions or state whatever it is that they need to state. We have the word vent here on the PowerPoint slide, but we don't always want the homeowners to vent. We understand that sometimes that's what they come to do. And of course, owners are not going to always ask questions. They're going to come and tell you whatever problems or whatever things that they see that are a nuisance to them in the community, right? But you want to set the tone for the owner forum before it even gets started. You can state that each homeowner will be limited to those 2 to 3 minutes, that we are going to steer clear from any personal attacks or negative commentary. Everyone be professional and respectful, those kind of things to help to set the tone for the forum. Because again, you can't really control what a homeowner is going to say if you're allowing for this in-person live open owner forum. In order to kind of control it though, I would consider asking homeowners to write their questions down either ahead of time or during the meeting so that they can turn them in during the time for the homeowner forum. And instead of having homeowners stand up or giving them a microphone to ask their questions or to allow them that 2 to 3 minutes to vent, you have the question that they're intending to ask, and you can just read it out and allow for a response to be given. And that kind of cuts down on the amount of time that's spent on the owner forum. It cuts down on things turning negatively. And it just kind of keeps things in control a little bit more. Now you can make sure that those questions are answered there during the meeting, or if it's something that you're not completely sure of, you can assure that homeowner that you will follow up with them in the future to get their contact information so that you can provide them an answer to the question that they asked if that question can't be answered during the open forum. Also, just remember too that sometimes the questions that you get might be a little off color, or they might be something that feel like a personal attack. So you want to avoid getting defensive if you get a question that's a little weird. Avoid getting defensive because that's going to change the tone of things, right? You want to keep everything positive, keep it on the up and up. So make sure that whatever questions are asked, you just answer them to the best of your ability. And if you can't answer them at the time, then follow up with that homeowner at a later time. I see a couple of questions rolling in. I'm going to answer those questions at the end so that we can go ahead and get through the material. So what is the definition of board meeting? We've talked about why we have board meetings, what can be done at board meetings, but the property code gives us a definition of what a board meeting actually is. Now, keep in mind that this is found in Chapter 209, which, as we all know, relates to single-family communities. There is no definition for a board meeting in Chapter 81 or 82 related to condominiums, or that can be found in the Business Organizations Code. But the Chapter 209 does provide us with this definition, and it basically states that it's a deliberation between a quorum of the voting board of the POA or between a quorum of the voting board and another person, which another person can be a community association manager, during which POA business is considered and the board takes some sort of formal action. So that is the definition of what a board meeting is, right? Now, let's just consider the scenario where there is some sort of event that is happening in the community and there are several board members present. Well, the property code does take that into consideration, and it states that an actual board meeting or an official formal board meeting does not include a gathering of a quorum of the board at a special function that's unrelated to the business of the POA or attendance by a quorum of the board at some sort of convention, right? Convention, ceremonial event, or press conference. If formal action is not taken and there is no discussion of POA business, then this is not a formal board meeting, but it's just a gathering that's incidental to some sort of social function, again, a convention, ceremonial event, or press conference. So really the factors that need to be, that must be present is that there is a discussion of POA business and some sort of formal action must be taken in order for it to actually be considered a board meeting. Without that, then it's not a board meeting, it's just a gathering or just a convening of board members. Now, what is the format of a board meeting? Of course, all of us know that we have our in-person board meetings, and then we all are aware that during COVID, we all had to make the decision to have virtual meetings, right? So Chapter 209 does take that into consideration. A board meeting can be held by electronic or telephonic means, but there are certain circumstances that have to be present in order for this to be a formal board meeting, right? So each board member has to be able to hear and be heard by every other board member. So that means that the sound has to be working properly. And except for any part of this electronic or telephonic meeting that's being conducted in executive session. Then all of the owners that are in attendance, because remember, we're talking about open board meetings that are open to homeowners. They also have to be able to hear all the board members. And owners should be allowed to listen using any electronic or telephonic communication method that can be expected to be used by a board member. So if we're talking about using a phone, if we're talking about Zoom, Teams, whatever platform is chosen, then board members and owners alike have to be able to hear everything that's going on, and everyone should be able to use all of the same equipment that everyone else can use, right? Now, of course, the notice of the meeting that goes out, if you're going to have an electronic or telephonic meeting, that notice has to include any instructions for owners to be able to log on or access the communication method required under the property code. So if we're talking about having a telephone meeting and it's a telephonic conference system, then you need to be able to provide the phone number and the password perhaps. Or if we're talking about using Zoom, then we have to provide the link or the meeting ID and the password. So everyone has to be able to have that information for it to be considered a formal board meeting, electronic or telephonically. And there could be some potential implications or liability if the notice that goes out doesn't have the proper information on it. Now, there are also some requirements under Chapter 82. So what I just talked about was Chapter 209. Again, that relates to single family communities. Now let's talk about Chapter 82, which does give us some specifics. So unless the declaration, bylaws, or articles of incorporation provide otherwise, which we can refer to those all collectively as the governing documents, then a meeting of a board can be held by any method of communication, including electronic or telephonic. Again, if proper meeting notice has been given, if every director can hear or be heard by every other director, and it cannot involve certain topics such as voting on a fine, damage assessments, appeal from a denial of an ACC approval, or the suspension of a member's rights before they've had an opportunity to be heard at a board meeting. So these are the requirements for Chapter 82 for the board meeting format. Again, those can be held by electronic or telephonic means as well, but we just got to make sure that we meet those certain requirements that I just talked about. Chapter 82 goes on to say that if the board acts by unanimous consent, we still are able to consider that information in a board meeting later on. So it kind of has to be ratified, so to speak. A record of board action is filed with the minutes of the next board meeting. So that's what I mean by ratifying it in the board meeting minutes. So if anything happens outside of a board meeting by unanimous written consent of the board, then during the next meeting, that needs to be ratified and placed in the meeting minutes so that it can be memorialized and it's a formal board action. All right, so let's talk about the board meeting itself. Under 209.0051, of course, a association meeting has to be open to members. Now, there's a difference between a member meeting and a board meeting. And so right now we're talking about board meetings. Chapter 209.0051 also provides us the definition of a board meeting, which I just talked about. Of course, meeting minutes are required for your open board meetings. I will get into a few specifics about meeting minutes in just a second. And every board meeting, every open board meeting is subject to the board being able to adjourn into executive session. Now, if the board is going to adjourn into executive session, there are certain things that should be discussed during that executive session. Things like personnel issues, pending or threatened litigation, contract negotiations, enforcement actions, confidential attorney communications, and any specific individual owner issues. Those are items that should not be discussed during an open forum because they require a little bit more privacy and more confidentiality. So they are to be discussed during executive session. Of course, anything that is discussed in executive session has to be summarized in regular session, including expenditures that were approved during that executive session, and also needs to be placed in the meeting minutes in a brief way, right? So that's what's required. A couple of other things about 209.051. If there is certain action that needs to be taken outside of a board meeting, then there are certain things that are permitted, but kind of similar to what I talked about in 82, there are very specific topics that are not permitted to be discussed outside of a board meeting. Here are some examples. There are at least 15 topics that absolutely must be discussed during an open board meeting. So we're talking about fines, damage assessments, initiation of foreclosure and enforcement actions, and so on and so forth. I won't read all these to you. You'll note that some of these things definitely are things that are a little bit more private and probably require some confidentiality and a little bit more tact. So when you adjourn into that executive session, some of these things can be discussed during executive session as well. Now, of course, you have to report things that are discussed at the next regular meeting and included in the minutes. So that I mentioned that before, but any action that's taken outside of a meeting, whatever is permitted, it needs to be reported at the next regular meeting and included in the minutes. So this is formal board action taken outside of a meeting. All right, so I mentioned there were 15 things. There are certain actions that absolutely require an open board meeting, and these are those 15 things. Election of an officer, filling of a vacancy on the board, ACC appeals after an approval or denial, increasing of assessments. You could see this little graphic, and I'm sure you've seen this graphic before because we use it quite often, but it just kind of impresses on our minds what those items are that absolutely have to be discussed during an open board meeting. All right, so of course, in order for us to have a board meeting, we have to send out notice. So Chapter 209.001 also provides us with the requirements for board meeting notice. Now, a notice specifically has to state the date, time, place, and general subjects that are going to be talked about during the meeting, including a general description of executive session matters. Of course, the executive session matters should not be too detailed, but again, a general description. In order to make sure you're providing notice in an adequate amount of time, the notice and the agenda need to be sent out no more than 60 days and no more than 10 days, or no less than 10 days before the meeting. So just remember that time frame, 10 to 60 days before the meeting. Or if the meeting is going to be posted on a website or in a common area or on someone's private property with their permission, and it gets sent via email to owners who have registered to receive things from the association via email, then the notice requirements are a little different. They can be sent out 144 hours prior to a regular meeting and 72 hours prior to a special meeting. So just keep that in mind. There are different requirements for condominium board meetings. So the association has to have a meeting at least once a year. In Chapter 209, it doesn't have any requirements for how often you have to have a meeting. That information can generally be found in the bylaws, and a lot of times it's really up to the board's discretion if they have a meeting once a month or once a quarter or even just once a year. But Chapter 82 is specific that the board has to at least have one meeting every year. And unless the declaration has some other information or provides otherwise, the 82 requires that special meetings of the association have to be called by the president of the board, a majority of the board, or unit owners having at least 20% of the votes in the association. And that's usually by some sort of special petition process. The special petition process is usually spelled out in the bylaws, but if not, then that can be found in Chapter 82 as well. So a couple more things about board meetings as it relates to condominiums, because they can be a little bit different than single family communities. And of course, the meetings will be run very similarly, but there are different rules. So of course, there are some similarities too, right? Meetings of the association and the board have to be open to all of the unit owners. So that's very similar to the requirement in Chapter 209. And also the board meetings are subject to a closed executive session. Again, board members or even the community manager needs to announce during the open meeting what the general topics that will be discussed in the executive session would be. And those items should be actions involving personnel, again, pending litigation, contract negotiations, enforcement actions, matters involving the invasion of privacy of individual unit owners, and matters that are to remain confidential by request of affected parties and agreement of the board. So these last two are a little bit different from what's in Chapter 209, but that's why it's important for us to understand the nuances and the differences and similarities between Chapter 209 and Chapter 82, because they are very different, very their own individual animals. And so we have to just make sure that we understand specific to the community that we're dealing with, what the requirements from the property code really are. As we all know, the property code supersedes really what the requirements may be in the bylaws or in the dedicatory instruments, the declaration. So we have to just make sure that we are kind of staying up to date with any changes. As we all know, we're in a legislative year. So some things may change before the end of the year. And so we just have to kind of, keep up to date with these things. That's kind of part of the reason why we do these educations. And so we make sure that we stay abreast of all the new developments and we keep you guys up to date as well. All right, and then another note about board meetings as it relates to condominiums. If a unit owner makes a written request for a board meeting to be held, then the association has to inform the unit owner of the time and place of the next regular or special meeting of the board. If the association's representative makes a request if the unit owner makes a request and the association's representative has no idea when the next meeting is happening, the time or the place or anything of the next meeting, then they need to promptly obtain that information and disclose it to the unit owner pursuant to their written request. And if there's not a meeting that's scheduled, then a meeting needs to be scheduled in order to provide that information to the owner and then hold that open board meeting. All right, well, let's talk a little bit about executive session because I mentioned this before. The executive session is the time during the open board meeting to discuss things that are a little bit more private and maybe need some confidentiality. Or if there is some sort of request for privacy, then that's the time for that discussion to happen. Now, during the executive session, no meeting minutes are actually taken. You should not be taking notes either. Really, you want to just kind of put your pencils down and just, have the discussion, pay attention to what's going on during the executive session, and just kind of talk out whatever the issue might be. You don't necessarily have any decisions to be made or any voting that happens during the executive session. The executive session is meant for discussion, but a private, confidential discussion that doesn't happen in front of the entire community. You want to do your best to limit the trash talk or gossip. That could be a really good time for trash talk or gossip to come up, because perhaps you are talking about a situation that, is a nuisance to a board member personally, or is creating a lot of drama in the community or something like that. But you want to try to keep that to a minimum and just kind of focus on the facts and focus on the discussion and how to reach a resolution possibly. And stick to the agenda. So there is going to be a general agenda for the things or the items to be discussed during the executive session. So stick to the agenda. Now, I'm going to say this again in a few minutes, but keep in mind that things discussed during executive session are not privileged or confidential the way that you would think things are like attorney-client confidential, or there's some sort of attorney-client privilege. So that's part of the reason why we recommend that notes are not taken, minutes are not taken, or anything like that, because it's really just meant for a private discussion to happen amongst the board members and perhaps the board's representative, the community manager. Now, after the executive session is over with, you are going to reconvene into the board meeting and summarize the decisions that are made orally. Place those decisions in the meeting minutes in very general terms, because again, you don't want to reveal too much information. You don't want to breach the privacy or confidentiality or even privilege perhaps of anybody that was discussed during that executive session. And you will also just kind of give a general explanation in that open board meeting of any expenditures that are approved in executive session. So if you're talking about specific contracts or anything like that, then that's the time when a discussion about expenditure approval in executive session should occur. Now, This is the second time that I'm going to say this, but minutes are not protected by attorney-client privilege, and they are discoverable. So, of course, executive session discussions would be generally, noted in the minutes. But even anything that you talk about in open session during the open board meeting, when you record them in the meeting minutes, you want to make sure that you are keeping a record of what was done at the meeting, but not what was said by the members. So meeting minutes should not be narratives. They should be bullet points, actually, just to kind of make sure that they are very concise, very brief, stick to what was done at the meeting again, and not what was said by anyone. No paragraphs, no notes about the discussion or anything like that. You want to make sure that you leave out your opinion, whether it is favorable or otherwise, because again, minutes are not protected by attorney-client privilege, and they are definitely discoverable. So don't put too much detail. Make sure you make separate paragraphs for each subject matter to keep things, concise and organized. But again, when I say the word paragraph, I don't mean like sentences. I mean like one sentence per bullet point to just kind of let everyone know what was done, what decision was made in those meeting minutes, so that when they are recorded in the association records and a lawsuit comes along for some reason, and you are producing those minutes, then there's no issues with that, because you followed my advice and made sure that you did what I'm saying here, which is to make sure you're keeping those minutes very concise, not too much detail, and very disorganized. All right, so one of the last things that I want to mention, and then I'll get to the questions that I see here, is that a lot of times when we're doing our meetings, we are using Robert's Rules of Order. Now, keep in mind, of course, Robert's Rules of Order is kind of an old school thing, and it can be very complicated. But the use of Robert's Rules of Order is not required unless it's provided for in the bylaws. I have been doing this for probably a little bit over 6 years, and I've never ever seen in any bylaws that I've looked at where it was required to use Robert's Rules of Order. We don't actually recommend using Robert's Rules of Order because it can be really complex, the process, and you really need to have a parliamentarian in order for it to be proper use of this method. And so, of course, you can, ask for a motion from the floor and have the motion seconded and those sorts of things, the bits and pieces of Robert's Rules of Order that we all use. But to try to adhere strictly to Robert's Rules of Order can be very complicated, and we don't recommend it. So you don't have to use it, basically. And maybe everyone's sighing a sigh of relief right now, because Robert's Rules of Order can be antiquated and just a little bit too much. So that's all I have for you, but I see that there are quite a few questions, so I'm going to go over to my chat box here. One of the questions that I see is whether or not the slides will be available. The slides will definitely be available, as well as this presentation is being recorded. So a little bit after we're done here, it will be posted to our website. So, right. So Kimberly mentioned the property code states that we must allow open forum for owners, but we can limit the time permitted. Absolutely, you can limit the time permitted. And that open forum can be done by way of allowing owners to submit their questions, so you can avoid having them stand up and, going off during the open forum. One question that I see is, how descriptive and specific should the agenda items be? I have a board member who requests extremely specific items and have found that it can be counterproductive to the meeting, right? So again, I mentioned that it should be general, right? So you don't have to, again, write a paragraph about what the agenda item is going to be. But let's just say, for example, you're going to consider security companies. So the agenda item should say the board will consider and vote on security companies, and that's really it. You don't need to get into too much detail. It does not need to be too specific, because then you would have an agenda that's going to be like 10 pages long. It allows for you to just have, for the owners or whoever's looking at the agenda, to have an idea of what's going to be discussed. And then the discussion itself happens during the meeting, and then it's recorded in the minutes. George asks, can a board amend bylaws if the bylaws specifically state that the bylaws may be altered or amended by the members, but the members can delegate such powers to the board? So if your bylaws state that the members have to amend the bylaws, then of course the members do have to amend the bylaws. But if there is a provision that allows for members to delegate those powers to the board, that can be done too. However, there is a provision in the Texas Business Organizations Code which would allow for a board representing a nonprofit corporation to amend the bylaws. And we take the position that that means that the board can amend the bylaws. So regardless of what it says in, if it says that the members have to amend, we take the position that the Business Organizations Code allows for the board to actually amend those bylaws. Kyle asks, is there a legal requirement to allow open homeowner forum during meeting? Yes, there is. But again, I would avoid having homeowners stand up and ask questions if you can, because that just kind of cuts down on the chaos. Celia asks, is it acceptable to have board members in person with everyone else in the community invited to participate via teleconference? Yeah, so one of the requirements that I mentioned is that everyone has to be able to hear and be heard, right? So that's the requirements for the board. The board has to be able to hear each other and be heard by each other. But also owners have to be able to hear everything that's going on, all the discussions that are going on amongst the board members. So if you have a setup to where, maybe there's microphones or something, or they're passing a microphone or something like that to make sure that all of the members can hear, then that's totally fine. And then I would also recommend that if you're going to do a homeowner forum, during that meeting where everyone else in the community participates via teleconference, or even if it's going to be by Zoom or some other electronic means, that you enable the hand raising function and have someone, perhaps the community manager, just kind of paying attention to that function so that they can allow people to ask questions, or maybe even to put their questions in the chat. So you're not just, so people aren't able to just mute or unmute themselves on their own. Let's see. Right. So another part to that question is if you're going to have the teleconference along, that's kind of like a hybrid meeting, then you need to make sure that you put in your meeting notice the instructions on how owners are going to be able to participate in the meeting. Now, if you're going to let them show up in person, that's fine. But if not, then you're going to say, well, the board will be present in one room, and then you will be able to log in or call in, and here's the password and that kind of thing. Again, yes, the slides will be available. So slide 16 talks about executive session. What is meant by personnel issues. So a lot of times the association has personnel that works for it. So it might be a security company or landscapers, or, maybe even the community manager, administrative assistants, that sort of thing. That's what I mean by personnel, people that work for the board, work for the association. For a single family subdivision, if bylaws allow for members or the board to make changes, can the board do so without first presenting changes to the members? Yes. So this kind of goes back to the question that I answered earlier. Under the Texas Business Organizations Code, we believe, or we take the position that the board can go ahead and make changes or make amendments to the bylaws without presenting it to members necessarily. But I would recommend that if it's a material change, that maybe you discuss it at one of the open board meetings, but it's not something that would be necessarily open for discussion for the entire community. It would just be the board relaying the amendment or the contents of the amendment to the rest of the community. All right, for Zoom meetings, if notice was sent for an in-person meeting, but the board wants to change it to Zoom due to inclement weather, can we do that the day of the meeting? So this making changes on the day of the meeting can be problematic because there are notice requirements. And of course, there are circumstances that are beyond our control. So if it's necessary to make that change to Zoom instead of an in-person meeting, then you want to make sure that you are blasting the fact that things are going to be changed, because kind of similar to today, right? We've got some weather alerts going on, and things might get crazy a little bit later on. So you have a couple of options. You can cancel the meeting and reschedule it, or you can have the meeting, but just make sure that you're blasting it out every way that you possibly can. And just let everyone know, due to inclement weather, we have made the decision to change to a Zoom meeting or a teleconference or something like that. Now, this doesn't mean that people won't come back and say, you didn't give us enough notice or, whatever. But if you're trying to protect people and to make sure that no one drowns or no one gets their car messed up or, has to come out in the weather, then you just have to make sure that you provide as much notice as possible. All right, the next question is, does referring a homeowner in violation of a deed restriction to council constitute initiation of enforcement action and therefore need to be summarized in general terms in open board meeting? Yes, so if you are going to send a matter over to the attorney's office, then that can be considered initiation of an enforcement action, whether or not it is for collection of assessments or a deed restriction violation. Now, a lot of times there can be a distinction made here, whether it's a file that's being sent over initially, like just, we're starting the process and sending out demand letters, or the attorney has come back to you and said, we've gotten no response from this homeowner and now we need to file a lawsuit. My recommendation is that you are having that conversation when you're turning it over to attorney, and also when you are making the decision to go ahead and approve or authorize the attorney to file a lawsuit, because I've had quite a few cases where opposing counsel is asking me for the minutes where the association made the decision to file a lawsuit on this homeowner. So, it can be done at one time or the other, but I recommend it is done at both times. So the next question is, if no decisions are made in executive session, then how do we get votes for the accounts to escalate? We said summarize decisions made once you go back to open session, but told us not to make decisions in executive session. So you make the decision, right? You have the conversation in executive session, and then when you close your executive session and come out, then you can say, now the board needs to vote on the discussion that was had during executive session, and you use some sort of identifier to identify whatever homeowner account or whatever homeowner that needs to be voted on, right? So it would go something like the executive session gets closed, you come back out into the regular session, and you say, during executive session, we talked about escalating accounts or initiating foreclosure action, and the board now needs to vote on whether or not we are going to move forward with that, if we're going to initiate the foreclosure action or initiate the deed restriction violation enforcement action. And so then the board gets an opportunity to vote, and maybe you're using a code number, an account number, or something like that to identify which owners would be sent to the attorney. But just, you're not going to use names or addresses because you don't want to identify the homeowner. All right, as secretary of the POA, I take separate minutes during executive session, which I and the president keep in our binders that are not published. This is for matter of record only, is just frowned upon. As long as the minutes, these separate minutes that you're talking about are not being published, it's not necessarily wrong to do, but again, I don't recommend because I wouldn't want this to be considered an association record. I understand that it might just be for your own personal purposes or, just for you to kind of look back on and refer to, but I would not recommend doing this just because, again, minutes or association records are sometimes not, they're not privileged and they can be discovered. So this is something that you just want to consider. I think I answered this question. Yes, you'll receive the presentation for future referencing. All right, if there's a board member that votes no or abstains from an electronic vote, how would you recommend that being recorded in the meeting minutes? So generally when a board member vote needs to be had, you need, depending what your bylaws say, you need a quorum of the board, or you need the majority of the board to vote in a favor or not, right? I wouldn't necessarily record how each board member votes, only that you received approval based on the quorum or based on the majority or not. So you don't need to record how each board member votes or if they abstain from voting. Do we have an example of sample board minutes? Sorry. I do. Helen, reach out to me afterwards. Just shoot me an email and I will give you a couple of examples of how board minutes should be kept. And The open forum questions documented in minutes. You don't necessarily have to document each question. You can just document the fact that there was an open forum and that questions were asked and that answers were given. The question is whether the business organizations code is recommended to use instead of Robert's Rules and Order. Personally, I would use anything other than Robert's Rules of Order just because it's so complex and complicated. But there are several provisions of the Texas Business Organizations Code that would probably be better. They would also probably be more up to date and more contemporary, with our time right now. And so, yes, I would use several provisions of the Business Organizations Code over Robert's Rules of Order. Brad, you can talk to Kyle about how to receive your CE credit. Let's see. I've answered this question already. Briefly speak to the different requirements for communities. Oh, okay. Could you please briefly speak to the different requirements for communities still under developer declarant control? So this question, generally, if there are communities still under developer declarant control, how they conduct their board meetings is going to be very similar, but there will probably be several provisions in the bylaws that govern this. So this is really going to be more of a case-by-case basis. You will need to look into your bylaws and look at the provisions that are specific to the declarant or developer and determine how the meeting should be run or what sort of things can go on during the meeting under these circumstances. And Kyra, if you want to reach out to me afterwards, I'll provide my email address so that we can kind of look at your documents and go over that. Let's see, does RMWBH have a template for POA bylaws that includes 209 rules for boards? So we don't really have a template, so to speak, because each association is going to be different and they are going to have different needs and they are going to, it will depend on whether or not it's a condo or a single family community and so on and so forth. So we really would have to take a deep dive into the current bylaws and the current rules in the Texas Property Code and the Business Organizations Code as they stand right now and create a document that's specific for that community. A single family neighborhoods board amended bylaws but has not presented them to community nor posted them on the website. They are filed of record, but they are not enforced. So the question says they are not filed of record, but are they enforced if not on the community's website nor emailed to members? So a governing document or a dedicatory instrument becomes effective on the date and at the time that it gets recorded in the real property records where that community is located. There are rules in the Texas Property Code that require dedicatory instruments to be posted on the association's website. Whether or not they're posted on the website, they're still effective, but they definitely need to be posted on the website. Let's see, when we send the initial letter, we take that to our board for collections or DRB, and they vote to allow the management staff to continue the process without further bringing it to the board. Is that permissible, or does it need to be brought to the board if it needs to be escalated further? Now that's permissible. So, earlier I was mentioning that there's 2 points in time where that provision of that I was talking about with regards to initiation of enforcement actions and whether or not it needs to be brought to the board. Does that mean that that happens when it gets turned over initially, or does that mean that it happens when we are requesting authority to move forward with the lawsuit? The argument can be made either way. If you want to be like extremely safe, then you can do it at both times. But I think that it can be argued that once you submit it to an attorney, then that's initiation of enforcement action. And then I think the last one was, sorry to clarify, owner forum is not required. An owner forum is definitely required, but it just depends on how you handle that owner forum, right? Are you going to do it? Are you going to let owners stand up and talk? And give them 2 to 3 minutes to, ask their questions or air their grievances? Or are you going to require them to write their questions down ahead of time and submit them so that they can be read off during the meeting and answered during the meeting to kind of cut down on the possibility or the potential for the meeting to go off the rails and you need security to come and escort one of the homeowners out or something like that, or even one of the board members out or something like that. That is all the questions that I have here in the chat. But as I mentioned before, if anyone has a question that comes up or something that I did not get to here that I didn't see, please feel free to reach out to me. My email address is nhicks@rmwbh.com, and I would be happy to answer your question. Thank you guys so much for joining me today. Be careful, be safe out there today. We're under a flood watch until tomorrow. And we all know what that means. Every time it rains for 5 seconds here in Houston, it starts flooding like during Noah's Day. So everyone be safe and have a great rest of your day. Thanks.